welcome. As we get into our discussion, we invite attorney at law Martin George to step in this morning to give us perspective. A very important discussion concerning the removal of the Privy Council. Obviously, the CCJ, there are many putting their voices, singing from the rooftop that this should be our final court of appeal. And the irony in all of this, Martin, is that the CCJ is located here in Trinidad, right? Stone's throw away.
Yes, it is.
On Henry Street and Charlotte, between Henry and Charlotte. So
yeah, that's right.
Yeah, I mean, so for the life of me, you know, it begs the question as to why. And you know, strangely enough, and again, good morning, Martin.
Good morning.
Good morning. So strangely enough, I'm watching BBC this weekend. I'm watching some of the coverage from Al Jazeera and all the other major networks. And you're seeing the Platinum Jubilee with the Queen and her 70 years on the throne, and people are celebrating Her Majesty. And yet still, I guess based on this Privy Council set up legally, we are still, in a way, tied to our colonial past.
Yes.
You know, strange enough, after all these years. Give us some perspective. Obviously, the CCJ is there, but we are not part of that framework just yet. How so?
Right. Okay. So, actually, we are part of the framework, and this is something I am happy to clarify for listeners and viewers, because you know it's a common misconception to say that Trinidad and Tobago is not part of the CCJ. The CCJ functions as two courts. It functions as a court in its original jurisdiction, which in that originating jurisdiction, it deals with matters concerning CSME, CARICOM, and the Treaty of Chagaramas. So in that regard, we are subscribers to the CCJ. Hence the reason you would have seen major cases, Jason, such as the case with TCL, Trinidad Cement Limited, versus Guyana. Remember when they had a dispute with Guyana over the tariffs and the rates to be paid and the importation of the cement and stuff like that. So the CCJ is actually the court to determine any such issue. So amongst CARICOM territories, once you have any issues relating to CSME, or you have issues relating to interpretations or applications of the revised Treaty of Chagaramas, then the CCJ is the court to which you go. And we in Trinidad and Tobago subscribe to it in that originating jurisdiction. Where we have not yet subscribed or signed on to it is in its appellate jurisdiction. Now, just to give a brief explanation, our system in Trinidad and Tobago, we have basically, you have the lower judiciary, which is the magistrates court, then you have the high court, then you have the court of appeal, and beyond the court of appeal is the Privy Council. So in other words, the Privy Council at this point is our final court of appeal. It's our court of last resort. Other Caribbean countries, such as Barbados, you have Antigua, you have Belize, they have signed on to the CCJ as their final court of appeal. Guyana has signed on also, right? So you have these countries which have signed on to the CCJ and said, hey, listen, we want the CCJ to be our final court, our final determinant for all matters. So we are no longer going to the Privy Council for the Privy Council to determine those things. Trinidad and Tobago has not yet signed on. And of course, it has been a bit of a political football between the government and opposition. And then when they change roles, their views seem to change, you know, in terms of, you know, whether they want it or don't want it, you know, as happens in our very bifurcated democracy here in Trinidad and Tobago.
Well, I'm watching here because I'm watching some of the notes, and I recognize you put forward a sentiment suggesting that there must be public trust for this transition to take place. Can you elaborate? What do you mean by public trust?
Okay.
Must be gained first before we transition to the CCJ.
Right, and I had said that before the events which played out this weekend, Jason, in relation to the situation in the Miami court, where our Honorable AG was called upon to step down from a matter or to step aside. You know, things like that, Jason, are the types of things which really tend to erode public trust and confidence in our legal system as a whole when they see something like that happening, because they will say, well, hey, listen, is this something which could have been avoided? Is this something which ought not to have even gotten to that stage where you had a Miami court making that ruling? And in fact, the AG himself was one of the proponents a week before that, saying, well, look, let's make the CCJ our final court of appeal. So the thing is, we have, of course, always that innate suspicion amongst ourselves as Caribbean people, as, Trinbagonians, where we don't tend to trust one another, to be fair, to be impartial, to be objective, to do the right thing in all circumstances. But that is not enough to say that that's a reason to not implement the CCJ as our final court of appeal. However, as I say, incidents such as what occurred and what we saw played out this weekend, they do tend to shake that sense of trust.
Interesting, because again, when you break it down for us, and I was making some notes, so the lower judiciary, the magistrates court, that's the lower judiciary. Higher judiciary will be the Supreme Court. And then we move now to the Court of Appeal, and then the highest court being the Privy Council in England. And yet still, we are tied to that in 2022. What needs to be put in place to remove ourselves from that? What will have to take place on a political landscape and within the legal framework for us to really transition and to tie ourselves wholly and solely to the CCJ?
Well, politically, you need the support of both the government and the opposition. So unless and until that happens, that will not be changed, because that you're talking about fundamental constitutional change. So without the support of the opposition, that will not change. And you see, it's at times like this that the opposition has tended in the past to wield their leverage and their power. But the fact of the matter is that it ought not to be used simply for punitive reasons. In other words, your power as opposition is really to be a balancing, act to, make sure that you keep the government in check. It's not to stifle or cripple necessary legislation. Of course, they have their reasons as to why they are opposing it. My reason that I have put forth, Jason, is that I have said that, look, the CCJ is a court that is still in its infancy. And while they have delivered some very seminal judgments and some very important judgments, I could quote the Lucas case from Belize. I could also cite the Tomlinson case, which actually applied to Trinidad and Tobago and also to Belize. That's the case that determined that, look, you cannot debar someone from entry into your country based on their sexual orientation, right? Because remember, if you recall, we had those laws in our books still, which tended to make that discrimination. And that Tomlinson case decided that, and that was a CCJ case. So they have decided some important matters. They've decided several major trade disputes between Barbados and other islands, between Trinidad and Guyana, between TCL and Guyana, as I told you. So there have been several major decisions that they have delivered. There's also the Myrie case in Barbados, if you recall, where the Jamaican woman was strip searched, and the CCJ ruled against Barbados in that matter, and they felt that the Bajan authorities were totally wrong, in how they treated that lady. So the jurisprudence is developing, it is growing, and I think that once they continue along this line, they will reach a point in time where it's going to be an inescapable conclusion for Trinidad and Tobago, because we will be able to point to a seminal body of work and say, look, this is what the CCJ has done over time, regardless of what your fears or your concerns or your suspicions are, or you feel, there's too much closeness that, we know the judges, we know who they are, and you are afraid that people may reach the judges or influence the judges, because that is part of what you hear as the narrative of some persons for saying, well, they don't want the CCJ as our final court. But that will be overcome, I think, Jason, once they've built up such a prodigious body of work that you will be able to see and say, hey, listen, regardless of what your fears, your concerns, your suspicions are, look at the track record, look at how many, serious judgments they've delivered, look at how many, important cases they've ruled upon, and they've done so impartially and, fairly and, judiciously. So therefore, they are really beyond that type of question or reproach or suspicion.
Martin, let me take it now to dollars and cents. I'm thinking here for those who step before the Court of Appeal, regardless of the case. Court, as you know, is always a massive financial undertaking. Some people have to mortgage their home, really run some hoops to try to obviously to fight their case.
Yes.
I would imagine if indeed the CCJ is the final Court of Appeal and one doesn't have to go to England to have your case heard and deal with their pound sterling, there might be some kind of financial implication to the client, and you could probably stay within some kind of reasonable budget. Would it be? Will it have a financial implication?
That's a very practical consideration, Jason. And in fact, there's been a study which has actually crunched the numbers and shown that it is 5 times more expensive for a litigant to try to approach the Privy Council as it is for the CCJ. So the cost saving is tremendous for most persons. And in that regard, that is certainly an incentive. But of course, you have those who are the traditionalists who still feel that, the law lords in England, are the ones best suited to decide their matter because they don't want any local person to have the final say on their matter. There's that concern that some people have. But I'll give you this, Jason. The Privy Council is always right simply because there's no higher court above the Privy Council, if you understand me. So because there's no other court sitting above them to say, hey, listen, you decided this wrong, that's why they appear to be always right. But even they themselves can sometimes be conflicted. And I'll give you 2 cases which are so interesting because they were actually decided on the same day by different divisions of the Privy Council. One is called Repolimis and the other is the Wagon Mound. They concerned charter parties with ships, and in those 2 matters, different divisions of the Privy Council came to totally opposite conclusions and gave their judgments. So you have 2 conflicting judgments from the Privy Council coming out on the same day in the same type of matter. So that alone shows you that the Privy Council is not always right. So we have to accept that. But as I say, because there's no higher court to tell them, well, you were wrong, of course, we have to accept their word as the final say on matters. And similarly, if Trinidad and Tobago adopts the CCJ, we will then have to accept the CCJ as the final arbiter on matters.
Is there a systematic push? Is there solidarity among the legal luminaries, people like yourself, your colleagues? Is there a collective voice pushing for this, or is it just a couple of people, just popping up and making this particular call for the CCJ to be our final court?
You have different views throughout the profession. I think most of the older and more mature senior counsels, they seem to still have a preference for the Privy Council. I guess it has worked for them in that way. I think maybe among the junior attorneys, you might tend to have more open-mindedness to the CCJ as the final court and the court of last resort. But at the end of the day, it really doesn't matter much what attorneys think, or, because it comes down to a question of the politics and who gets the votes. And if you don't get the support of the opposition in the matter, it's not going to happen because it requires that type of special majority.
But that's another irony, because the parliament is filled with attorneys. Most people who occupy the walls.
That's right.
Attorneys at law.
That's right. But the point is, they, I think, shed their attorneys' robes for their political caps, and therefore they, sing to the tune of their political masters in those circumstances.
Interesting. You think in our lifetime we'll see it, Martin?
I think it will happen. I think it will happen. And as I said, as the CCJ continues to build up its body of work, I think the conclusion will be inescapable that, look, hey, this is a court which has proven itself, it has established a track record, and it has therefore, the gravitas and the gravamen to be able to be willingly and readily accepted as our court of last resort and our final court of appeal.
Interesting indeed. Is Jamaica part of this? I know you mentioned Belize, you mentioned Barbados.
No, Jamaica still goes to the Privy Council. And if you recall, Grenada in 2018, they actually had a referendum where they tried to get views from the public, members of their public, as to whether they wanted to, ditch the Privy Council. And the population in Grenada voted overwhelmingly that they wanted to retain the Privy Council. So Jamaica still retains the Privy Council, so do we, so does Grenada.
Interesting, because I remember the case, and that's a current case right now, of embattled dancehall star Adidja Palmer Vybz Kartel. His case now is before the Privy Council. They will have a final say as to if his case will be deemed now as a mistrial. So I guess the Privy Council still very much relevant in the Caribbean.
Very much so. And you see, I think, Jason, part of it is because of the familiarity, in that we know the judges of the CCJ. Some of them have, come from the Trinidad and Tobago judiciary, some have come from the Jamaican judiciary, the Guyanese judiciary. So in other words, you know them, and there's that familiarity. And of course, with that familiarity is the innate suspicion that, well, maybe this one knows that one, and they might rule, in that way, or they might be influenced by this person. And I think that is what causes the problem.
Interesting, Martin. I want to thank you for the perspective. Always a pleasure. I'm sure we will touch base soon on some of the leading topics of the day. So until then, you be safe.
Indeed. It's always great chatting with you. Have a great morning. Thank you.
That's right. Attorney at law there, Martin George. We come back after the break with more. Stick around. You and